Welcome for today's lesson. This is JK Online Accounting Tutorials, and today we are going to learn about the law of agency. Now, introduction. Basically, an agent is a person who is employed to do an act for another, called the principal, or to represent another in dealings with a third party. So from that point, the law of agency usually results into the creation of two contracts. One is a contract between the principal and the agent. Another one is between the principal and the third party through the agency. Now, under a contract of agency, the agent is authorized to establish a contract between the principal and the third party. That is what I have just explained. And an agent is merely a connecting link and is relieved of personal liability, except for certain circumstances that will be discussed later. Types of agents. Number one, we have a general agent, who is an agent engaged to perform a particular task or transaction on behalf of the principal in the ordinary course of his business, trade, or profession as an agent. While a special agent is an agent whose authority is restricted to the performance of a particular task not being in the ordinary course of his business, trade, or profession. So you can see clearly the differences there between a general agent and a special agent. Like a particular agent, his authority is restricted, while that of a general agent is not restricted. Let's go to the next subheading, that is the different types of special agents that we have. Number one, we have a broker, who is a mercantile agent, and basically is described as a mere negotiator. This is because he is neither entrusted with possession of goods nor the document of title. That is different from a factor who is also a mercantile agent, but is entrusted with the possession and sells the goods on his name. Then we have the third type of specific agent, that is an auctioneer. An auctioneer is a mercantile agent who is licensed by the state to sell goods and other property by public auction. He may or may not be entrusted with possession, but is an agent of both parties. Then we have a declaré agent, who is still a mercantile agent, and in return for an extra commission known as commission, declaré guarantees solvency of a third party with whom the principal contracts. So essentially, the declaré agent will indemnify the principal in case the third party fails to honor his or her obligation. So he may or may not be entrusted with possession of goods or documents of title. Creation of agency. Now, an agent relationship may come into existence by the following ways. One is by agreement, contract, or appointment. This is whereby the principal expressly or impliedly appoints or enters into a contract with an agent for the agent to act on his behalf while dealing with third parties. Then we have the second one by ratification, by estoppel, by necessity, by presumption, or from cohabitation. So agency by ratification. To ratify basically it means to validate or to confirm a transaction which was done by another party who proposed to act on your behalf. Now, when the principal ratifies that kind of a transaction, basically we have some legal effects. There are some legal effects to that. One, the agent's relationship is created, and the second one, all the transactions entered into by the agent are validated, and the last one, relieves the agent from any personal liability. But not all transactions can be validated, and we have the following conditions for a valid ratification. So this condition must exist before the legal effects of ratification can take place. Number one, the agent must have purported to act for a principle that women should not have dealt on his own name. The second one, the principal must have had capacity to enter into contracts when the agent did, as well as when he ratifies it. We mean that capacity to contract, basically it is the ability to contract. So a person like a minor, an insane, or a convict, they are denied the capacity to contract. So such persons cannot ratify the transaction. The third one, the transaction entered into by the agent must be capable of ratification. In other words, we are saying they must be legal. They should not be illegal or void. Now the fourth one, the principal must ratify the transaction within a reasonable time. Now reasonable time will depend on the nature of the transaction. It's not really defined. Then we have another condition, the principal must have been aware of the material facts affecting the transaction. In other words, we mean the person purporting to act as your agent must provide details of all material facts pertaining that particular transaction, and when the principal ratifies the contract in its entirety. Agency by estoppel. So agents can also be created by estoppel. Estoppel is basically an equitable doctrine. It arises when a party by words or conduct represents other third parties, represent other two third parties as his agent, and the third parties deals with the agent. The other party is stopped from denying the apparent agent. So it is the court of law that will issue this decree to stop someone from denying the apparent agency. And there are conditions or requirements for agency by estoppel. Number one, a representation by word or conduct intended to be acted upon. That is number one. Number two, the third party relies upon the presentation by a representative. The third, there is a change in legal position as a result of that reliance. And the final condition, it will be unfair not to stop the representative. That's why we are saying this is a doctrine, it's an equitable doctrine. Agency of necessity. An agency created by law in circumstances of necessity, where one party is deemed to have acted as an agent for another. Basically, agents of necessity are said to have presumed authority to act, and not all acts can be termed as agents of necessity. Below are the conditions for agents of necessity. Number one, there must be a genuine emergency necessitating action in relation to the goods. Number two, it is impossible for the party in possession to seek instruction from the owner. Number three, the party in possession must act in good faith for the benefit of the owner. So if these three conditions exist, then basically an agency of necessity can be created. Duties of an agent. The following are the duties of an agent, that is performance. Number one, the agent must perform his obligation. Number two, is obedient, should obey the principal's instructions. Number three is care and skill. Number four, account. Then personal performance or non-delegation and delegation. So an agent should not generally delegate his authority, but there are certain circumstances where an agent is allowed to delegate. For which will be discussed later. Then we have bona fide, we have keep the principal informed, secrecy or confidentiality, separate account, this is for the purpose of accountability, and we have the disclosure. So now let's discuss the exceptions to the rule that says an agent cannot delegate. So an agent is allowed to delegate his authority in the following circumstances. One, where it is authorized by the contract between the parties. Number two, where it is authorized by law. Number three, it is authorized by trade usage or customs. Number four, where it is effected with the principal's knowledge. Then where it is reasonable necessary for performance. Another one is where special skill is required, and the last one in case of an emergency. Authority of an agent. So what an agent is usually given is authority. Now this authority is the ability of the agent to affect the principal's legal position in relation to the third parties. Authority implies permission to do or engage in a particular task. So the principal can give authority to the agent, and when that is done, then you say this is a real or actual authority, which can be expressed, implied, or customary or usage. And then there is another kind of authority which appears to have been given. Now this is from the conduct of the principal, and this one we call it apparent authority. And the last one is presumed authority. This one is created by law, and it is presumed to have in certain situation, and agents of necessity usually have presumed authority. Rights and remedies of the parties. And now the rights of the principal is basically to dismiss, that is in case of misconduct, and also rights to sue or court action. And this one can be basically for many reasons. It can be maybe because of fraud. The agent has committed a fraud, so the principal can sue the agent. And we have rights of the agent. Number one, right to sue, right to lien. Lien is basically a claim on the assets of the principal. Then we have the third one, rights of stoppage in transitu, that is to stop items or goods that are being transported, they are on transit. Then withhold the passing of the property, that is in case there is a sale of goods and the ownership has to exchange hands. So the agent has a right to withhold the passing of the ownership until his issues are sorted. You have personal liability of the agent. So the following are circumstances where an agent is personally liable. Generally, in the law of agency, an agent is not personally liable because he is or she is representing the principal, and the legal position which changes is that of the principal. But there are certain circumstances where the agent is personally liable. Number one, where the agent expressly or impliedly consents to a personal liability, that is if he agrees to be personally liable through his conduct or through word of mouth or in writing. The second one, where the agent negligently or recklessly fails to indicate the agency. Yeah, that's a scenario then personal liable. And where the agent executes a deed in his own name, that is represent himself as the principal. Then we have where the agent exceeds his authority. Then where the principal does not exist or has no capacity, as was the case in Kellner versus Baxter. So if the principal has no capacity to contract, then basically the agent will be personally liable. And the final one, where an agent executes a deed in the principal's absence in circumstances in which appointment was not by deed. Termination of agents. So agents are like any contract, can be terminated, and the following are ways in which an agent's relationship can come to an end. Termination, basically we are saying the agent's relationship coming to an end. And number one is through an agreement, that is the principal and the agent agrees to terminate the agency relationship. And the second one, withdrawal of consent, that is renouncement. The relationship is renounced. In the third, the death of either party, that is either the agent or the principal dies, then the agent's relationship is terminated. In the fourth one is by performance, that is if the agent performs his duties and the principal remunerate the agent, then basically that is by performance. And by performance we mean all the parties do what they are supposed to do, they honor their obligation. Then we have lapse of time, that is if the agent's relationship has a time limit, then if the time lapses, then the agent's relationship is terminated. Then we have insanity, and this insanity can be for either parties. If the principal or the agent becomes insane, then it means they are denied the capacity to contract. It is a disability that can deny someone the capacity to enter into any contract. Then we have bankruptcy of the principal. Now, according to the law of bankruptcy, when someone is declared bankrupt, all his material are usually transferred to an official receiver, who sometimes is appointed by the court of law. So when that happens, then the principal is denied the capacity to contract. Then frustration of the contract is when an event has happened rendering the performance of the contract impossible. Then we have destruction of the subject matter, cessation of emergence, and cessation of cohabitation. This is when an agent relationship is formulated out of necessity. Thank you for listening to me. Below are revision questions that will help you prepare for your exams. They are arranged in the year in which they were tested. These are CPA questions on agents, and if you look at the question, you will find that this topic is tested in every sitting. So it's important that you understand and revise well on this.